like to now introduce our next speaker, Mr. Amar Singh Pasri. Mr. Advocate with 28 years practice at New Delhi, having completed an undergraduate degree in science from St. Stephen's University in 1989, and then read over the University of Oxford, returning to India in 1992. He started out at J.B. Dadachandji and Company in 1992 and then founded his own law firm, International Law Affiliates, in January 1998, and is now counsel to the firm, appearing in international and commercial arbitrations and appears before the High Court and the Supreme Court. Mr. Pasrich is a regular speaker at several international conferences of the International Bar Association, Union International de Avoca, IPBA, to name a few. His clientele consists of corporate clients, builders, multinationals, foreign governments, airlines, and individuals in connection with disputes that have involved multiple jurisdictions. He also represents several foreign missions, including His Excellency, the British High Commissioner, the Canadian High Commission, the French Embassy, and the Singapore High Commission for several land matters and tenancy disputes. Mr. Pasrich is a member of the Doon School Compliance and the Vice Society of India. Mr. Pasrich is the chairman of the Law and Justice Committee, PhD Chamber in Industry. He is also a senior officer of the International Bar Association and presently the counsel of the Legal Practice Division of the IBA. Mr. Pasrich is co-chair of the India Working Group of the International Bar Association and has formerly co-chaired the International Commerce Committee and has also represented India on the IBA Council. Mr. Pasrich, I now request you to please share your views with us on the various aspects of litigation in relation to real estate.
Yes, good evening. Am I audible?
Yes.
Yes, you are audible.
Okay, good. That's the first question you ask nowadays. A year ago, we never asked that question. Thank you very much for the kind introduction. I actually should have spoken to you at some point and requested you to cut it down to at least half, if not less. I apologize for the length of that profile sent by my secretary. From my point of view, I'd like to first address my co-panelists, Honorable Chief Justice Mohit Shah, Dr. Lalit Bhasin, for whom I have tremendous regard and respect, who I have known, I think, from the day I joined the legal profession when I was a very junior person, and appeared in the first IBA conference that he was chairman of, going back to 1997. I'd like to acknowledge the CII for having organized this excellent series of webinars, and Mr. Anil Harish for his subliminal kindness, his tremendous ability to include people and to have organized it so well with his gentle approach, which has always been extremely professional. I'd also like to thank Kshitij Paliwal from my office for doing a lot of research that has helped me to get where I'm going to go. My co-panelists, Mr. Adiraj Harish, Mr. Neerav Jani, Mr. Sudhir Kumar, who's an old friend, and Mr. Vikas Mohan. Thank you. I have a PowerPoint presentation, which perhaps the CII could share if it's available. Right, that's fine. Thank you. So this is the topic. My topic is real estate dispute resolution, and I want to pause on that topic name for a bit. That is wide enough to cover a speech that could go on for days. It's wide enough to cover many, many angles of law, which would make it rather boring also. I have tried over the last few days when we put this together to come up with something interesting, not hyper-technical, a little bit related to Delhi, which is where I'm from, and to also give you a perspective on issues that I find often are not known either to the general public and sometimes not even to lawyers. So I'm going to raise those issues. If you take us to the next slide, I'll explain why. Now, curiously, when you look at real estate in India, one of the few things that is not often discussed is the impact of the word rights in rem versus the rights in personam. And I feel that would be worth discussing to some extent, not only because it comes up in litigation regularly for us as lawyers, but also because there is a subtle twist that is coming about as I see it in the law in this field. So I'm going to quickly take you to a case which most lawyers never forget because it's called Booz Allen. And then I'll talk about that. Further below, if you look, you'll find some reference to rent control and the Transfer of Property Act. I haven't actually developed this, but I will speak on it uh, a little bit. And I think I could do that before we change the slide because there are no slides on this. I wanted to say that as far as rent control and the Transfer of Property Act are concerned, I'm surprised to find that there is such a divergence across India on how rent control and the Transfer of Property Act are envisaged. We have done some research and we have found that almost every state has a divergence, different thresholds for when the act, the Rent Control Act kicks in, and then there's um, the parachute of the Transfer of Property Act. So I want to start with just a comment on that journey so that perhaps I can leave some thoughts in your minds about what constitutes the issues arising from rent control. There are now in almost every state different forms of eviction practiced, different forms of threshold to get into the rent control tribunals, and also then the interplay between the Rent Control Acts and the Transfer of Property Act become part of the issue of what is rights in rem and rights in personam. So I will briefly be discussing that when I come to the case of Booz Allen. Since I have not putting up any slides on this, I think I should just add that from my own personal experience in litigation, where I have had HPCL or a very big very big company use the protection of the Rent Control Act in one state, that was UP. Uh, we find that there are some states that don't allow big corporations to use it, and there are some states that do. So those lacunae in the law still persist and surprisingly are quite disharmonious. So that's my comment on rent control and the Transfer of Property Act. Most lawyers are very familiar with these two forms of eviction and the specific provisions of Section 106 of the TPA, how to give a notice, how to file an eviction, how to use it in a tenancy matter. So I'm not going to go into that in great depth in the rest of my presentation. Now, coming further down, if you look at this list, you'll find I refer to the foundations of the right to property. This is an interesting aside which I'd like to mention. This you'll see is the movement which surprisingly a lot of young lawyers are not conscious of the right to property, which has gone from has journeyed from Article 19(1)(f) to Article 300(a). So I'm going to quickly focus on that. I see some interesting developments in succession law, which I'll be discussing. And further down, when we reach municipal law, which can be very boring for Bombay lawyers, because I am looking somewhat at Delhi, I'll take up about 5-7 minutes of this presentation on what happened in Delhi. And because it's Supreme Court, I don't think you'll mind the comments which emerge from that because they may affect Mumbai. I must say, Mr. Doctor, and I don't call him Doctor yet, gave such a wonderful presentation that I have a hard act to follow. He spoke very well, and he spoke with a lot of detail on the regulations which have come about with so much development over these years. And and appreciating the comment he made at the end, it's similar in Delhi. We have also been trying to protect our city and its development through these judgments which have come from the Delhi High Court and also the Supreme Court. To be somewhat topical towards the end of this presentation, I talk about the COVID-19 impact and specifically for landlords and tenants, and slightly peripherally from land, the question of force majeure. We can go to the next slide. Now, why does it matter? It matters to mention to those, even lawyers sometimes, to remind them what is a right in rem and what is a right in personam. And so we've just quickly compiled two slides to mention these. That would be the availability to the whole world of your remedy, because it is not deriving from contract. It derives very much from something that is exercises when against the whole world. And the second one is in personam, derives usually from a contract and is personal to two people. So that's a very important distinction. Can we go to the next slide, please? Now, when we talk about actions in rem, determining the title of property, I find that in India, we have a very interesting dichotomy and divergence, because rights in rem and rights in personam sometimes merge in their approach. And that's where we'll be talking a little later about the question of lease versus license, and when the distinction blurs and how the courts have to assess it. And in that, I'd like to make a quick comment here also, that one of the reasons why we have so much litigation in India, and I've written two pieces about 7, 8 days ago, which Mr. Harish very kindly pointed out, on the pendency pandemic. And one of the reasons is almost everything that we have in India boils down to judicial discretion. So we have not created hard lines or laws or rules by which something is very clearly this or that. We still depend very much on trial, evidence, and then we look at something after sometimes 15 years, which we consider quite reasonable. So taking up Mr. Harish's comment there, versus 3 months. And sometimes we take, now this is very interesting, we can take 69 years. And in that respect, I'm referring as an example to the Babri Masjid case, which came out at the end of 2019. I don't know if many of you had a chance to read the judgment, but essentially that judgment is a matter of property rights and whether they were exercised in rem against the world at large or not. And if you read the unanimous judgment of the Supreme Court, it's very interesting that it all relates largely to the question of exercise of those rights going back first from 1857 and then later on from 1950. And the first suit is filed in 1951, second suit is filed in 1959, and then we have first and second suits are filed in 1950, and then we have further suit filed in 1961 and 89. So all those suits are clubbed together and decided in 2019. Now, please consider the effect of the judicial discretion that it takes to determine something so big. That one, of course, is a very spiritual case and involves much more than just property. But the fact of the matter is, to determine these questions, we often refer back to the judges, the courts. The Supreme Court always has to step in to decide, the finer issues when it comes to a big matter. So if we go to the next slide, please, I'll take up this theme furthermore. Yes, so this is Booz Allen Hamilton, which people laugh at the name often because it's a company where a question of mortgage was up in the context of an arbitration agreement. And the question was whether the matter could be decided by a private arbitration. Now, don't forget, here is the question of the rights in personam and whether the rights are capable of adjudication is determined by the question of whether they are personal rights or whether they are rights in rem. Rights in rem should traditionally go to a court or tribunal, but not specifically to an arbitrator. If you could go to the next slide. Then, if you look at this, the decision of the Supreme Court in 2011, not so long ago, was that adjudication of certain types of proceedings is reserved by the legislature on public policy grounds only for the courts and tribunals. This also weighs heavily on the courts because our real estate questions must go to court of necessity following Booz Allen and also some previous cases which Booz Allen depended upon. So effectively, one of the reasons why we have more litigation in the courts is because of this decision that the rights in rem must be determined by uh, by the courts and tribunals. I am not going to read at every stage the extracts that I put onto your screen because I'm sure you're all very good at reading, but where it's very important, they are in bold. And what I want to say from this slide is uh, the words may by necessary implication stand excluded from the purview of private fora. These are very heavy words. And what Booz Allen has done is to leave it back to the courts to decide whether by necessary implication there's going to be a decision or whether they stand excluded from the purview of private fora to be tested by litigation. And that's the problem because everything leaves itself open to discretion and testing by the courts. Go to the next slide, please. Thank you. Thank you. Now, if you look at the Booz Allen decision, it says what is not arbitrable. These are the well recognized examples. And if you look at number 5 and 6, they talk about testamentary matters, eviction or tenancy matters governed by special statutes where the tenant enjoys statutory protection against eviction. So Booz Allen, right from 2011, has made it clear, and it should perhaps have been clear even before that, that certain things could not go to a private forum. But is this at all doubtful? I'll just be explaining to you that it is. Come to the next slide, please. Now, if you read the decision in Booz Allen, one of the pillars of that decision is a right in rem is a right exercisable against the world at large. And then they've explained what is a right in personam. So if you founded yourself on that, that means that almost all property rights, the moment you get possession, would no longer be amenable to a decision by an arbitral tribunal. Please go to the next slide. Now, again in Booz Allen, when we were examining the judgment, we have generally and traditionally all disputes relating to rights in personam are considered to be amenable to arbitration. So there was a line and a very strong wall drawn between what is arbitrable and what is not. But pause here for a second, and this is why I put this slide up. This is not, however, a rigid or inflexible rule. That means that it's open to a decision of the courts. Let's go to the next slide and appreciate where we're coming from here. Now, please look at, you can't see the top of the slide, but it's this, we're still on Booz Allen, and we've got, this is the 6th slide. This is to do with a mortgage suit, and it's about enforcement of the mortgage with reference to an immovable property. And so Booz Allen held that this cannot be decided by an arbitrator. But look below, it says further, even if some of the issues or questions in a mortgage are arbitrable or could be decided by a private forum, the issues in a mortgage suit cannot be divided, meaning, therefore, that if one or two issues can't be decided, the whole dispute could be taken out. That's a line in Booz Allen. Please come down to the next line. Now, this was followed in the context of the Delhi Rent Act, and we see that in 2017, the Supreme Court looks at the Delhi Rent Act and comes up with a decision that there's a special act. It contains a provision by virtue of it. The provisions of the act do not apply to certain premises. But that does not mean ipso facto that the Arbitration Act would be applicable. Now, by implication, that also does not mean that it would be not applicable. Continue. In such a situation, the rights of the parties and the demised premises would be governed by the Transfer Property Act, and the civil suit would be triable by the civil court and not by the arbitrator. In other words, this is the decision of the Supreme Court. By virtue of Section 3 of the Delhi Rent Act, provisions of the Act are not applicable to certain premises, but no sooner the exemption is withdrawn or ceased to have application, the Act becomes applicable to such premises. In this view of the matter, it cannot be contended that the provisions of the Arbitration Act would apply. So effectively, the in personam remedy was excluded, and the Supreme Court, following Booz Allen, said, in this special context of the Delhi Rent Act, no question of applying the Arbitration Act. Please come to the next slide. However, now you can't see the name at the top because it's blocked by a little label, but it's Vidhyad rolia, which is at the top of your screen. And this is a 2019 case where the Supreme Court, I think it's Justice Nariman's decision, while appreciating that a lease is a transfer of an interest in property and therefore a conveyance in law, there is nothing in the Transfer of Property Act to show that a dispute as to determination of a lease arising under Section 111 cannot be decided by arbitration. So why am I bringing this up? In fact, I wanted to show you all that there is a subtle shift and there is a movement for obvious reasons. Hard and fast lines that prevent cases from being decided outside the tribunals and courts will have to slowly be eschewed. This is a policy the Supreme Court is beginning to move towards. And if you look further, what was argued was that Section 114 and 114A, which provide for statutory reliefs against forfeiture for non-payment of rent and breach of an express condition, would indicate that the statute itself is based on public policy in favor decided by the courts only. So the word only operates very clearly here. That means that according to the Supreme Court in 2019, these are rights in rem to be decided only by courts. Please come to the next slide. But the Supreme Court does not consider that to be the final word, and it comes up with this. Section 114 cannot be a provision conceived for relief of tenants as a matter of public policy. The reasoning continues, and it applies to the considerations under those sections. And then the Supreme Court says all the grounds under 111, as also sections 114 and 114A, are grounds that could be raised before an arbitrator. So the subtle shift in the law from 2019, which is clear here, is that the courts are letting arbitrators into fields that would previously have been reserved for the courts and tribunals. Now, this matter is not the end because, of course, there was 2017 Himangani had to be overruled, and that comes in your next slide, which is, next slide, please. The consequence of Vidhyad rolia is that the court, referring to Himangani, said it may be noticed that none of the provisions of the Transfer of Property Act have been dealt with in that judgment. Okay, so there is more. If you look at the bottom, equally, merely because a discretion has to be exercised by the court on whether or not to grant specific performance would not militate against a specific performance being granted. And they're supporting Booz Allen. It is clear, therefore, that the judgment in Himangani will require a relook by 3 judges. So here is a distinction, here is a change in the law, which is probably going to come in effect within a few months. I thought that's worthy of bringing to your attention as an interesting issue. Now let's go to the next slide, please. Now, I'm bringing this point up of leave versus license, leave and license versus lease versus leave and license, because it's a very important principle for particularly Bombay lawyers, and I say that with a fond smile. They invented this creation called a leave and license agreement, and there are some people in Delhi who have used it. It's still not in common use, but across India, the license has slowly gained popularity for the simple reason that a license protects the owner better. And if the license is not conferred with certain language, and it's the Bombay lawyers are the best at this, um, it does not transfer possession. There are certain specific clauses they use, which I've enjoyed reading, whereby they say that notwithstanding handing over the keys, etc., possession is not transferred, and then the licensor has the right to walk in whenever he wants. Those kind of words, the right becoming a right of user rather than a right of possession, that is the right in persona that is transferred by a license. So you have these judgments, which are on your screen, which talk about from 1959 onwards a right of user and then permission to use land without exclusive possession. And I have to say that from my experience, and I've done some litigation on this in Bombay, in the Bombay High Court, and I'll call it Mumbai from that point of view, but from the Bombay High Court, and in Delhi also, where the question of possession, the question of the language of the lease has been very critical. And if you take the classic use of the language that is now put into force in most cases, you get a very useful leave and license agreement, which can be terminated at will by the licensor, and the licensee is left with nothing, even if his possessions are inside. So those things work, and they have been used if they're properly drafted. And that's an interesting point which I wanted to make. Now, if you come to the next slide, we talk about what has been stated by the Supreme Court more recently, in which they also say that it doesn't matter how you classify the document. If it's called a license, but it doesn't have the elements of a license and it doesn't effectively protect the licensor from transferring possession, then the court will again apply its discretion. And I'm complaining strongly against this tendency of our Supreme Court and of our courts to keep things close to the chest and say, oh, we'll decide it on a case to case basis, because what it means is that rather than laying down, these are the clear antecedents of a license. If you check these boxes, it's a license. If you check those boxes, it's a lease. What we have is that the Supreme Court says, and this is in 2004, that these words are not decisive. An effort has to be made whether the deed confers a right exclusively. That effort, the word effort, is a very wide word. It could be used to suggest, discretion, as always. And then if you read the rest, it's even worse. It comes to the conduct of the parties. The moment you use that language, then you have to go away from the document and you go to evidence, and you take 20 to 30 years to determine whether this is a license or a lease. Now, that is critical for you as members of the public, as members of the legal fraternity, to understand that you're in a very precarious position. And if you are from the licensee's point of view, you can actually go to court and say, notwithstanding the language of this license, I'm entitled to a stay while you determine from the conduct of the parties as to whether or not this is a lease or a license. So that is something, it would be nice if that was clarified. And it's still, as far as we have been able to research, I may be wrong on this since there's so many judgments every day, this has not been clarified yet. Next slide, please. Now, I want to take you back to 1978 because it's an important change that came about in independent India. For those of you who are conversant with the history of the country, this was a time when it was done for certain political reasons. I can't go into those. This is not a political speech, so I have no interest in the background. But what I want to say is that from a constitutional fundamental right to property with various protections built in, we moved this right to property, which had to exist, it's a very important right, to a constitutional or legal right. That's to Article 300A. And it's interesting, what that means is it is no longer part of Part 3 of the Constitution. It doesn't get the umbrella protection of Article 32. And in addition to this Article 300A right, uh, it can be abrogated by law. So the state can take away your property, even if you don't necessarily consider that to be fair. That's the bottom line. We can go to the next slide. Now, this is part of the journey, and I asked Mr. Paliwal, my colleague, to find me the judgment where they talk about the Article 300A right. I'm not going to read this, but I just want to give you a judgment, since there are still quite a few slides I have to go through, where they talked about how the right operates and what was the effect of this right. And this was a case where this is discussed in great detail. So if we can go to the next slide, please. Now, one of the things that I have an interest in is a recent judgment which has emerged from the Supreme Court a few weeks ago. And I thought we don't all have the time to read it. So it would be an interesting interlude for you all to have a look at what the Supreme Court has done in August or September 2020. So let me take you back to 2004 or 2003. And I have a personal interest in this. In the year 2004, I filed a writ petition in the Supreme Court, which was drafted by myself and Mr. J.R. Midha, as he then was, who became Justice J.R. Midha. And the writ petition was for exactly the relief which came about in the Hindu Succession Amendment Act 2005. When we filed the writ petition, Mr. Ashok Desai appeared, and it was the shortest hearing that I recall of such significance, because the Chief Justice looked towards the government and they said, "We'll take instructions." 6 weeks later, they had taken instructions and said that the writ petition should be allowed. It wasn't going to be allowed as it was, but they were going to move a bill in Parliament. And within a few weeks later, the bill was moved, and the Law Commission report that was of 2000, the year 2000, came to be enforced, and we had the Hindu Succession Amendment Act of 2005 come into force at that time. Now, the Act, if you look at for those of you who are familiar with the Act, sets a date in 2004, December 2004, 20th day of December 2004, where if something has taken place before that date, then it's not to be disturbed. But if it happens after that date, then a woman has an equal right, which was what our writ petition was about. In fact, we were keen to get rid of this abominable Section 23 of the Hindu Succession Act 1956, which created a clear distinction and was, to me, constitutionally invalid. When we came to Section 6, it had much wider implications. And now what we've got is that women have an equal right to property, and we've gone through this litigation. And here is the Supreme Court's latest ruling. I was not a party to this case, Vinita Sharma versus Rakesh Sharma in 2020, but it is a 3-judge bench, and it is important. In this case, there's been some clarity given by the Supreme Court. It's on your screen. The provisions contained in the substituted Section 6 of the Hindu Succession Act confer the status of co-partner on a daughter born before or after the amendment. Now, this word is very important, before or after. Now, why does it matter before? Because when we're talking about 2004, you're saying that she has a right to co-partnery from the time of her birth, as long as there wasn't a partition. Now, I'm bringing this out because here's another area of the law which is open to more interpretation and possible litigation. These read the next line, the rights can be claimed by the daughter born earlier with effect from 9/9/2005. So this is what the majority of the judgment says. It is that a daughter born even before the act uh, has every right and becomes a co-partner as long as the partition has not taken place, right? And then if you read the point number 3, since the right in co-partnery is by birth, it is not necessary that the father should be living on 9th September 2005, which is the date of the act. Actually, I think it's 5th September. Now, if you go, it was notified on 9th September. If you go to the next slide, please. Now, we're talking about a statutory fiction created by the proviso to Section 6 as it was originally. Now, that was an unfortunate proviso that existed up to 2005. And it talked about ascertaining the share of a deceased co-partner when he was survived by a female heir. Now, if you look at the bottom of this slide, you'll notice, notwithstanding that a preliminary decree has been passed, the daughters are to be given a share in the co-partnery equal to a son in pending proceedings. What this means is if you filed a suit, now we're not going to look back to the Babri Masjid as an example, but certainly if you take a suit that could reasonably still be existing, it could have been filed in the 90s or the early 2000s, even before the act. And if the partition was under challenge and the challenge is successful, then suddenly you're transporting a whole family back long before the act, possibly even to the 80s or early 90s, when the partition might have taken effect. So these are things that will start hitting our courts soon. Could you give us the next slide, please? Now I'm moving on to something totally different. Now, I don't know how much time I have, but I'll try and move a little faster. I think I still have about 10 minutes. So I wanted to give you a flavor of an interesting Delhi case, which happened in 2006. We did not participate in the case when it came out at that time, but I was involved with litigation that followed immediately thereafter. And we were surprised at the extent of this judgment, which, when you read it, it's a 3-judge judgment of the Supreme Court in the MC Mehta case. It was the judgment as it stands appears to be quite fair and quite easy to implement. It was talking about Section 345A of the Municipal Delhi DMC Act, Delhi Municipal Corporation Act, and effectively there was a slight jump in interpretation which the Supreme Court did, um, which was uh, surprising, the interpretation, because what it says is that the word erection, which is defined to erect a building in the Act, I don't have it here with me right now, but I'm speaking from memory. The word to erect a building in Section 331, once you read that definition carefully and read it along with the powers of sealing, could mean that a misuse of the Act or a conversion of user would come within the purview to erect a building. Now, if that happens, and this is what the judgment says, then it became possible for the municipal corporation to seal a building for simply conversion of user. And there's a Supreme Court judgment on that, which, as I said, came out in 2006. Could you take us to the next slide, please? And in this same judgment, it came to the Commissioner of MCD to exercise the power of sealing in case of misuser. And it was held that under Section 345 of the DMC Act, there is, well, the High Court had held that there was no power, but the Supreme Court held that the Commissioner of the MCD had the power to seal, but the DDA did not. Please go to the next slide. Now, in this, you'll find that the Supreme Court has effectively said unauthorized development for the DDA, that is another law, would not allow them to seal. Then look at the bottom of the screen and you'll find, unlike Section 331, there is no provision in the Delhi Development Act to confer on the authority the power of sealing in the case of misuse. So DDA has no power. Please turn to the next slide. Now, here's what happened. The Supreme Court, please see that this has changed. At the top of your slide, you'll see the citation has changed. It's no longer 399, it is 429. This is the next decision, which happens about a month later. The Supreme Court appoints a monitoring committee, and it empowers that monitoring committee to effectively decide whether the MCD, which was empowered by the previous judgment to seal, is doing its job or not. Please go to the next slide. Now, why is this relevant to us today? Well, we're 14 years later, the MCD has been acting in Delhi, and so has the monitoring committee, effectively or ineffectively. Well, there was a recent judgment of the Supreme Court delivered, I think, in August, in which the Supreme Court, in the same case, has curtailed the powers of the monitoring committee. Now, it is quite apparent that particularly when the monitoring committee is not empowered to take action, incumbents should not be deprived of the due process of protection in accordance with law. Now, as a lawyer, I want to pause here for a second. Having been in that court with people whose properties have been sealed, and that too with hours of notice, I have to say that this was a very welcome three-judge statement of the law, and a necessary one. If you look at this paragraph, it's really quite shocking that, as against the actions of the monitoring committee, no appeal lies elsewhere except to the Supreme Court. And the monitoring committee is not a creature of statute, it is a creature of a judgment under Article 142. Now, it's very necessary for us, and as Mr. Doctor said, we have to protect our heritage. We have so many things to do. And there's been eloquent statements from amicus curiae in the Supreme Court stating how necessary the monitoring committee has been for Delhi, because there has been rampant misuse and overconstruction and all sorts of things. The question is that, do our courts and should our courts be stepping in with such wide statutory, effectively legislation through judgment, to enforce provisions of law which exist? And then you find in this judgment, I have read the whole thing, it's quite amazing how we have the state actually opposing the sealing and supporting the people whose premises were sealed. So the state has ceased to be a state that does its duty and protects the public trust doctrine. I think, I'm sure Mr. Doctor mentioned, in the properties, and instead the state is standing up for political reasons, which is popularity, of course. The Delhi government was well represented in this judgment, so was the central government, and we have additional Solicitor Generals of India standing up and stating that this relief was needed, and the court gave it rightly. In fact, it was necessary for them to give it. The point I'm making, this is an important point, is that where the state has failed, and this does not relate to this particular government or even the previous government, it goes back for decades. We have to determine a procedure and a system that is safer for our country, and in that, I think we need to look away from the courts. They're not meant to make law, they're meant to enforce it. Please come to the next slide. This is again from the same judgment. It came upon the Supreme Court in August 2020 to fix the problem and to rein in a monitoring committee appointed in 2006. It was a committee comprised of retired civil servants, honest retired civil servants, but they're still in place and continuing to act in 2020, and they obviously exceeded their brief, so they needed to be reined in. But the Supreme Court continues to endorse the monitoring committee even today because, frankly, the city needs it. So this is the state of the law in that. From the Delhi side, I apologize for the Bombay lawyers if I've taken you onto a field that is quite different from your normal work. Can we go to the next slide, please? I just want to read this last part of the judgment. I didn't realize we had another one, but this is quite good. So the judgment in the Supreme Court now says we're not going into the merits, whether the premises are authorized or unauthorized, can be regularized or not, compounding can be done, or whether there's any deviation. Surprisingly, the monitoring committee has been doing just that in Delhi. And it says the report of the monitoring committee and findings by it are of no use as it had no such authority to go into the various questions. This court did not appoint the monitoring committee concerning each and every residential building on private land, not misused for commercial purposes, and to deal with the same. But the question is really what happens with the last line? It has not taken away the powers of the statutory authorities, but it has effectively the judgments of 2006, by continuing the monitoring committee today, have taken away our statutory remedies. And that's something that I leave with you. Please turn to the next slide. Now, this is the last part of my presentation, and I hope that it's of some use in the sense of the current crisis. Energy Watchdog is the last statement of the Supreme Court on force majeure, which had nothing to do with real estate. And interestingly, the Supreme Court said it's governed by the Contract Act, and it's not so much a matter of statute, but not so much a matter of the Transfer Property Act. Here it came as to what is a force majeure event, and it looked at it in the context of sections 32 and 56 of the Indian Contract Act. Could you go to the next slide, please? Now, in the context of section 32, there has to be a provision. So this is totally divorced from section 56. If you have enforcement of a contract and there is a provision, it has to be read literally. And if it's contingent on that provision, it covers force majeure, the provision will be read as the force majeure clause. And if you read Energy Watchdog carefully, and we're coming to the next slide, I will do that for you. Section 56, which is on your screen, an agreement to do an act that's impossible in itself is void, is totally divorced from section 32. Now let's go to the next slide. Now, here is where the Supreme Court said, if an untoward event happens and section 32 is triggered, you have a clause, and the clause doesn't cover you, you can't say that the frustration is your second option. Please go to the next slide. And this was made clear in these words, in the judgment itself. So we have effectively a judgment on the question of force majeure. Does it or does it not get covered by the contract? If it's not covered by the contract, does section 56 come in? Section 56 is divorced from section 32 only for one reason, and that is once the force majeure clause exists and is triggered, then the contract is not voidable. But if the contract does not provide and the contract effectively becomes void because a totally different situation has emerged, then you can use force majeure to say, I don't want to perform. Now go to the next slide and we come to real estate. This is again from Chitty in the same case of Energy Watchdog. It's what I've just explained. Please go to the next slide. Now, this is the last finding of Energy Watchdog on the fundamental basis of a contract. And what I've just explained is in this extract. It's at paragraph 47 of the judgment. Please go to the next slide. Now, I wanted to come to the Transfer Property Act in the context of force majeure and the COVID situation. Surprisingly, this is covered by an 1882 statute, which is perfectly in force today. And as far as I was able to find out, this statute was as it is today in 1882. So here is section 108, subsection capital B, rights and liabilities of the lessee. You need a material part of the property to be wholly destroyed or rendered substantially and permanently unfit. Then only, at the option of the lessee, the lease can be void. No other provision given. Now please turn to the next slide. And this is considered by the Delhi High Court. And the Delhi High Court enforces this and says, Section 56 of the Indian Contract Act would not apply to a lease agreement. And you can't use force majeure in that context simply because the premises have not been rendered unusable. Please go to the next slide. Thus, for a lessee to seek protection under subsection 108BE, there has to be complete destruction of the property, which is permanent in nature due to the force majeure event. Please go to the next slide. And mere non-approval by the concerned authority, in this case it was a restaurant, that doesn't constitute force majeure because the premises exist. So effectively, in these cases, what we find, that is Energy Watchdog, read with Ramanand versus Girish Soni, that the courts will not liberally protect the tenant who is suffering very badly from COVID-19 and say that you have rights. But what they have done, and they've done it in many cases, is they've brought them together, they've mediated, and they've said, look, why don't you balance your rights? Some tenants have left, they've lost their deposits, or they've packed up their goods and left. They've negotiated new rents. That's happened across the board. But the law has been stated, and it exists quite strongly in favor of the landlord. Now we come to the next point, please. Next slide. And now this is a very interesting point from the Delhi High Court, Justice Pratibha Singh, in relation to some contracts which are not classic tenancy or lease agreements. That is, those agreements where you have a sharing of the turnover, etc. You have to look at the clause. That's all that the judge is saying. That's a profit sharing arrangement, etc. Go to the next slide, please. Now, I just wanted to bring about one case from England where a tenancy agreement was said to be frustrated because the street leading to the property was blocked. It was blocked for a long time thanks to some zonal regulations, and they went to court. And I think it was House of Lords decision. I'm sorry, I haven't given the citation. It's quite an old decision. It said that the doctrine of frustration would rarely apply to leases. And although this is not cited by the Delhi High Court, it's not cited certainly, of course, in Energy Watchdog, it is the foundation for the principle. In National Carriers versus Panalpina, effectively it says, unless the premises themselves are rendered inhabitable, unusable, the lease continues until you terminate it in accordance with its terms or in accordance with law. I think you'll have to see the next slide. It's a very important slide, very exciting. I have to wind up on that front and say thank you. You'd heave a sigh of relief that he's finally finished. Thank you all for your patience in listening on this long journey relating to dispute resolution in land. Thank you, Kshitij, for your help